And it seems like this could be viewed as being calculated to try to be a method to get the death penalty off the table by waiting until the end to bring to the court's attention the contention that you can't get through all the discovery.
Wow, Judge, in your own words, how would you describe the accusation you just made against Ann Taylor?
Conspiracy theory.
Like you, be strong to hold the powers of the sun.
I show you how deep the rabbit hole goes.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And in this episode, we're going to break down probably the most interesting of those motions from that hearing that we heard. And that is the one, of course, regarding the advanced timing records from AT&T. And it also relates to that affidavit that Cy Ray had written up for the judge that the judge considered a conspiracy theory. Now, there's a lot of ways you've got to look at this particular issue because it is not cut and dry by any means. In fact, this has been probably the most contentious issue that the defense has dealt with this entire time. And I have to believe deep down, in fact, I'm confident that the reason that they want to do certain things when it comes to the trial is because they know certain things and they can prove certain things. So nothing about this case is happening in front of your eyes that is not very calculated by both the state and the defense. So you have to understand that there is a plan. And I think Ann Taylor made that clear throughout the hearing. I mean, they had a plan. Some of their plan has been shuffled up because of the recent actions of the state and what they're trying to introduce, but they have a plan. And you can bet every single thing, like in that funnel, I'll show you the evidence funnel here when we get towards the end of the video, but every single thing in that evidence funnel that the state is going to put forward, the defense is going to have a response to overcome it. So, for example, the fact that the state is going to have circumstantially that, Bryan Kohberger was wearing gloves, separating his trash. They're going to try to use that as more circumstantial storytelling to create a narrative and continue to plug points into that narrative to try to convince the jury that Bryan Kohberger is guilty and that those are conscious acts of a guilty person. Well, Ann Taylor and team files a motion saying Bryan Kohberger has autism and explains why those things that they're witnessing are just part of his personality. So everything that the prosecution puts in that funnel, the defense has a plan to counter it. So there are a lot of cases the defense is like having a defense in a fight. You got to have a good defense before you can implement a good offense. So that goes right along with these time and advance records. And the key is what was the defense hoping to achieve by opposing the prosecution's motion for limine regarding the defense not being able to bring up the advanced timing records at trial. This is a big issue. So instead of me just trying to lay it all out to you, we're going to watch the testimony. I'll stop it as we go through there, and I'm going to show you some key points. And this one you probably want to pay close attention to because this is not new information as they're going through this. I'm going to show you the history of this particular subject, the importance that it has, how I feel like the defense is going to use this to annihilate the state's case at trial, but also all of the things that I hope the defense has gathered during this long time that they've been working on it so that they can annihilate the state at trial. So I know that's as clear as mud, but let's go ahead and get into it. We're going to watch the testimony. I'm going to stop it periodically and point out some things, and then I'm going to give you my interpretation of the big picture in this thing, because it is big.
All right, let's talk about the AT&T stuff.
Thank you, Judge. This should be fairly simple. The state's seeking an order prohibiting the defense from continuing to allege that the state received timing advance records from AT&T for Mr. Kohberger's
When you
phone.
say continuing to allege, I'm assuming you mean in front of a jury.
Yes, what we don't want, throughout the entirety of this case, they've alleged that. We're seeking to prohibit them from making that same allegation in front of a jury because it's false. Timing advance records, really timing is what's at issue. And in 2022, the days that we're concerned about are 7 days. The event that we wanted records for was obviously November 13th. So in 2022, we had 7 days from November 13th to get AT&T timing advance records for anyone's phone. We did do search warrants for other people's phones. We did a tower dump, and we did a search warrant for 3 individuals. Those were all done on November 16th within that 7-day period, so the state did receive some timing advance records. However, by the time that Mr. Kohberger was identified in December 19th, and by the time we applied for a search warrant for his AT&T records, we were outside of that 7-day window, so there were no timing advance records to be received, and we did not receive any. The state has submitted an affidavit from Stephen Gordon, the AT&T Director of Compliance, essentially stating that we sought timing advance records, but they were not included because more than 7 days elapsed since November 13th, 2022, and the date of the search warrant, December 23rd, 2022. And the state just submits these affidavits should be dispositive of this issue.
Defense filed a document yesterday, and I don't have all the attachments, but it talks about a timing advance that was produced by AT&T in last April, I think.
Yes, so for that, it's still in reference to these search warrants that were initially asked for in November 16th of 2022. We did a part 1, and then later we did a part 2. But because we put in that request within the first 3 days, obviously a preservation request was also put in. So those records were obtained. So again, we're talking.
You're indicating that there were records obtained as part of your prior notification of need for AT&T to preserve those records.
Right.
Okay, there's a couple things right there already. And one thing that's funny to me is how the guilters out there want to say how bad the judge tore up Ann Taylor and defense team, told Cy Ray he was a conspiracy theorist, and just demolished them. But they're not quite sharp enough to realize the defense won this motion. I'll show you that at the end. The judge ruled in favor of the defense. He's going to allow the defense to question Agent Balance on the stand out of the presence of the jury, but still question him on the stand as it relates to why he didn't use time in advance records and if they existed. He will order that at the end, and the prosecution, they're going to be in trouble. But when people think that, oh, yeah, just tore them up. Well, open your eyes, folks. They won the motion. Prosecution didn't get their motion in limine granted on this. But you heard a couple of things right there in this particular segment that I got to point out. One was the judge mentioned an affidavit with information that the defense had filed the day before. And here it is right here. You can see this was a disclosure from one of the defense's experts. This was an additional piece of evidence that Cy Ray had Ann Taylor enter into the record. And what that said, the judge just clearly laid it out for us, was the fact that they were able to obtain time in advance records for those dates in April of 2024. Yeah, in April 2024, they went back and got additional timing advance records for people for those dates.
Obviously, a preservation request was also put in.
So here's the real question that the judge either is missing altogether or he's intentionally missing it. If the state obtained all of those timing advance records for all of those people back in November of 2022, and Ashley Jennings had filed a motion to preserve, so motion for AT&T to preserve those records, how come when the defense won the motion to compel the discovery for timing advance records back in April of 2024, how come the prosecution didn't just turn over the timing advance records for those people that they had obtained back in November of 2022? Why was it necessary for them to even have to go back to AT&T and request those records again to turn them over to the defense? They should have already had them and should have just been able to turn them over. You see, that's where things get kind of fishy right there. And I believe that's the argument that Ann Taylor tries to make. But for some reason, the judge can't comprehend that, or he doesn't want to.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance records.
What evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor, specific...
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records, on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for the time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way that...
The other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once, and they said, oh, no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
Okay, so that right there was actually critical. You see, the judge, as he stated, you know, this is a serious issue that could potentially cause Miss Jennings to be disbarred. So he's handling this situation with kid gloves. You can see it. Now, Ann Taylor also has to handle the situation with kid gloves because she wants to win the motion. A lot of people say, well, she just didn't argue and explain it well enough. No, actually she did, but she couldn't get argumentative with the judge because, number one, the judge was handling this situation with kid gloves. The judge actually kind of threw Ashley Jennings under the bus, though, with the outcome of this thing, and I think he did it on purpose, but he did it very subtly. But Ann Taylor, she can't go up and start just arguing with the judge and saying, no, wait, you're just not hearing me. She's making these statements. The judge hears those statements. He's acting like he doesn't, but he does, and she is making the statements. You see what you heard right there as he starts bringing up these 7 days, and he's going to hammer these 7 days. But what did Ann Taylor say right there?
You've heard from AT&T that GLDC did not produce these records in 2022.
You see, that's the crux of the issue. The first filing said that AT&T's Global Legal Demand Center did not produce timing advance records in 2022. So when the state comes back and says they could get them for 7 days, well, who gets them for the 7 days? It's not the AT&T Global Legal Demand Center. They never do answer the question of how do they get those 7 days of timing advance records after they made the statement of the Global Legal Demand Center did not produce any timing advance records in 2022. And Taylor points it out. The judge glosses over it, but you can bet he heard her.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
The 7 days that he's back home,
maybe.
I'll ask the state about those, if they receive those. I'm not sure their search warrant covered that time frame, but
Your Honor, I would say that it did, and I would say their first search warrant was just a 48-hour period. It asked for timing advance records, but then the second warrant,
you would
which
agree there's no evidence that AT&T provided those or that those were still available by the time that Mr. Kohberger was identified?
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that, and here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from people that I've worked with.
You're giving me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay. But you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance records.
Because they were asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay. So where is the evidence that Mr. Kohberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Again, the judge has to realize the ridiculousness of the question that he's asking Ann Taylor. He's saying, basically, what is the evidence? Even though the evidence that timing advance reports were produced in November of 2022 has already been answered by the fact that they had timing advance records for other people in 2022. But And everybody that that was requested time in advance records for 7 days, they requested those on November 16th. So they had 7 days on all those people from the 16th all the way back to the 9th of November. So when they requested the timing advance records and Bryan Kohberger's AT&T warrant, which was a mirror copy of the other warrants that they had issued, the defense has already explained that. So at the very least, they should have advanced timing records for Bryan Kohberger for 7 days prior to December 23rd, but the state won't produce them. And that judge is asking, what is your evidence of this? Basically saying, if you've got those records, you need to produce them and show them to me. But Ann Taylor does not want to do that at this point. So she's not going to say, well, here's the evidence, here's the advanced timing records right now, because that would blow it for trial. You can bet she has obtained them, though, because as she just mentioned, she obtained time in advance records from AT&T for November of 2022. She said she did. So they've already got Kohberger's advanced timing records. And here's the big deal about all this. What they're trying to do is get Agent Balance on the stand. And you're going to see what the judge says in just a little bit. The question Ann Taylor wants to ask him. The question Ann Taylor wants to ask him is, why did you not use timing advance records in your expert determination of those 7 critical minutes when Kohberger left his apartment, and in your determination on those 23 prior trips to Moscow? That's what she wants to ask him. Now, what she's going to have to ask him first, though, because the judge has set this up for her to do it, is, did you have access to advanced timing records for Bryan Kohberger in November of 2022? And based on how he answers that question, I mean, there's a myriad of things that could happen. If he says no and they have proof of it, then his credibility is gone, and all of his expert opinion on those 7 minutes and the 23 trips is gone. So that would negate one of the biggest pieces of real evidence in the case. The other thing is, if he says, well, we did have them, but I didn't want to use them because of whatever reason, well, then Ashley Jennings is automatically disbarred. So her just being able to ask Special Agent Balance those questions is tremendous. And that's why the prosecution wanted to try to limit them from being able to ask those questions. But the judge was slick about it. I mean, I'll tell you how he ruled here at the end, but he was very slick about the way that he went about doing this. But let's continue to listen, and then I'm going to point out something else that is really big, and I don't know exactly what it means. I'm pretty sure what I think it pertains to, but I don't know exactly what it is they're trying to uncover with it. But you can bet, I mean, this defense team has a set plan on every little thing that they do, and it's kind of fun figuring out what they're doing going, as we go through this. But let's continue.
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't, because they didn't know who he was.
You're correct. They didn't know who he was until, I think, about December 19th.
Correct.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. Even if they were just the 7 days back, I haven't seen any of them.
What you're talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past particularly about the 7 days. That's newer information to me now. But the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my attention
Our
more
motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
You see right there, that's where the judge was hoping to rescue the state, especially Ashley Jennings, on those timing advance records for those 7 days. And that's why he stopped her and said, look, this was a motion to compel issue. You should have filed a motion to compel if this information was, so important. And when Ann Taylor says we did, we've been litigating this thing for a long time. We've had many motions to compel on this very important information. But see, the judge thought he was going to outthink her and said, yeah, but on the 7 days, because he knows that this 7-day stuff never came up until the prosecution's reply. I mean, they filed a motion in limine saying they couldn't get the records no matter what for 2023 when the defense filed their response or their objection and put in there, yeah, you can, here's the proof. Then the state came back with the, well, it's 7-day thing and never said how they could get them from the 7 days. So the judge is trying to piggyback off of their 7-day argument and hope he can save them. But when he asked them, well, yeah, but in your motion to compel, it didn't include those 7 days. But Ann Taylor kept her composure and said, Your Honor, our motion to compel included timing advance records for any days, all of them the state had, which would have included those 7 days. And that's when the judge went, because he knows that their goose is cooked now, because he knows that they should have those 7 days based on their search warrant and everything else he just learned about this issue. So now things are going to get real. Let's continue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that, and you...
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
He is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days, and he had supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put it into any context. The state had indicated and provided AT&T sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that that was available to them by the time Mr. Kohberger was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel, through the FBI, would have been, did you get them? because I've heard different things along the case, asking him the question is really what I wanted to be able to do. And that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury
Thank you.
at the time of trial.
That will satisfy me. Thank you.
I'll let you ask that question outside the presence of the jury
Thank you.
at the time of trial.
That will satisfy me. Thank you.
See, it's amazing to me how people watch this and think the defense got their butt kicked from one end to the other, when right there, when the judge said, I'll tell you what, I'll let you ask that question outside of the presence of the jury at the time of trial. Basically, what's going to happen, I mean, the defense just won that motion. And you've seen Ashley Jennings and Bill Thompson will go to shuffling in their seat because they know the implications of that. What'll happen at the trial is before the jury is allowed in, they'll bring in Special Agent Balance, put him on the stand, and Ann Taylor gets to ask him those questions. Now, he's going to go on to make one more powerful statement, and you can tell that he realized the impacts of what was being discussed in that argument, and we'll talk about that here in a minute. But there's something else I've got to mention as it relates to this subject, because the timing advance records are not only so important because it pinpoints those critical 7 minutes and puts Kohberger in a place where he can't be the car on camera at Floyd Cannabis Shop. It also pinpoints his location during those 23 trips to Moscow, when they're going to imply he was surveilling. And since the FBI agent, Special Agent Balance, they've got his disclosure. So he's going to get up and testify, that he was in those areas and where he was so that he can let the jury imply that he was surveilling. It's very important. But also, it turns out the defense really wants that 7 days prior to December 23rd. They want that as well for some reason. I'm not sure if they don't already have it. I'm thinking they probably already have all of his time in advance records and they're setting the state up. But the reason those 7 days are very important, they probably want the prosecution to have to enter those time in advance records because Cy Ray probably get in trouble for the way that he obtained them. So I'm sure there's an issue with, being able to admit the evidence and stay clear. But here's the deal, because you go back to that hearing on April of 2024 when Cy Ray testified, and this was the interesting part. You see, he kept saying that from December 23rd, when they obtained the search warrant for 48 hours of phone records for Bryan Kohberger, in that search warrant, they had a request for the timing advance records. And then in the second search warrant for 6 months, they had the other request for the timing advance records for the 7 days. So that's why they should definitely have those 7 days. But why it's important is the fact that he testified to a couple other things. One, that the time frame between when they obtained the first AT&T warrant and they filed for the second warrant was like an hour. And he testified that it was impossible for them to get the information back on the first warrant, actually be able to analyze the data, and then file for the second warrant in the period of time that they did. So that's impossible. What he was implying was they already had that data when they filed for the second search warrant. So that's the defense's suspicion, and maybe they have evidence of it at this point, but it was their suspicion that the FBI, through the federal grand jury, had already obtained Bryan Kohberger's information on his cell phone prior to December 23rd. It's my suspicion that they obtained that on December the 16th, because that's when they got his information from Kopacka's phone. And that is why that Ann Taylor has been fighting for the original subpoena request for the grand jury for 2.5 years, and she's never received them. The state doesn't want to provide those original subpoena requests because you can bet in there is the subpoena request for Bryan Kohberger's phone on December 16th. That's why she overly states it was December 19th before they got Bryan Kohberger's name, according to law enforcement and the IGG. They know that they got his name prior to December 19th, or they would not continue to hammer that so hard. They know that on December 16th, in my opinion, they got Kohberger's information. The FBI, through the grand jury, the federal grand jury, subpoenaed his phone records. And then there's something that happened between December 16th and December 23rd. And I can tell you exactly what happened. Once they did that, they thought Bryan Kohberger was a suspect, meaning the FBI. The FBI then scrambled trying to figure out where Bryan was because he wasn't at his apartment. So what did they do? They got a stingray and a trap and trace, and then they tried to locate him, and then they put eyes on him once they did. That's why Howard Bloom was right. They found him in a Cessna. FBI found him and his dad traveling across the country, flying in a Cessna airplane because of that stingray device. But they tried to hide all of that for some reason. I know the reason, because their original confidential informant is a perjurer. So they try to hide all of that. And they're wanting to keep Kopak out of it for some reason. I know the reason, because if you put Kopak in it, then you've got two suspects, and then you've got a conspiracy. So they're trying to keep it, well, for the college town, it was Ted Bundy. But if they get those 7 days, because Cy when he testified on the second warrant, he said a couple of things, and I could play you the whole testimony, but he said one of the things that they requested in the second search warrant was a stingray. And he said, now that's $1 million piece of equipment that rides around in a van. He said, I had seen many reports that stated they already had eyes on Bryan Kohberger prior to filing for this warrant. So for them to file for a warrant to get a stingray to be able to locate Bryan Kohberger, he said, was disingenuous. So it didn't make any sense for them to do it at that time. It would have made sense if they did it just a little bit earlier. So what he was implying right there is they had already had all this stuff. The FBI already had all this stuff, and then they were having the state file these search warrants just to create a paper trail for the state for them to refer to in the investigation, because they've hidden everything the FBI did. But when you take all of the information from the last 2.5 years, from the previous testimony, then it becomes clear what actually took place in this situation. So the real question is going to be is, has the defense obtained this proof in a way where they can enter it into the record and impeach the state's witnesses? If they do, and they can figure it out, and they're playing they're walking a tightrope, but if they do, well, then it's going to negate one of their 3 actual pieces of evidence. Well, they get 4. There are 4 actual pieces of evidence. The cast history on location is 1. Vehicle identification is 2. We know that's not his car. We've already identified that's not even his car. Number 3 is witness testimony, eyewitness testimony, DM, which is, she didn't even identify him. But their other piece of evidence, strong evidence, is the DNA on the knife sheath. But if you eliminate the cast on his location, you impeach eyewitness testimony, because I assure you, they're going to show that she wasn't even there. They know everything that I've presented to you here in the last month. It is spot on, and the defense knows it. So when you impeach the witness, when you impeach the state's expert on location, then all you have left is the DNA on the knife sheath and the vehicle identification, and that vehicle identification's out the window. So all they got left is DNA on the knife sheath, which means they've got nothing. But the judge threw one little caveat at the end of this, and I know poor Ashley Jennings is probably hadn't slept since this hearing because of it.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
So the 7 days that he's back home,
maybe.
I'll ask the state about those, if they receive those. I'm not sure their search warrant covered that time frame, but.
Your Honor, I would say that it did.
Watch Ashley and Bill's reaction when the judge says this.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That,
So the 7 days that he's back home,
maybe.
I'll ask the state about those, if they receive those. I'm not sure their search warrant covered that time frame, but
Your Honor, I would say that it did.
Now, we are all completely on the understanding that AT&T did not produce timing advance records for the state in 2022. They clearly said the Global Legal Demand Center couldn't get those till 2023. However, they have obtained timing advance records for almost 4,000 people for 2022. So it clearly didn't come from AT&T. So when Ashley Jennings drags up with her tail between her legs to that stand to answer that question, the judge said, I'm going to ask the state about those 7 days. Well, watch the answer that she gives. Does she say, we did not receive timing advance records in 2022 from Bryan Kohberger in any way? Or does she say, we did not receive timing advance records from AT&T for Bryan Kohberger? Let's hear what she has to say.
I'm not upset, but I just for Mr. Ray's information, because he wasn't here the first day I started this trial with you folks. I said, I don't want theatrics. I don't want accusations that aren't supported with evidence about supposed bad conduct of the parties. You're all professionals. I respect you all. And the accusations he made in there are very concerning. The kinds of accusations, if true, that would get people disbarred. And so without any evidence and apparently sidestepping the clear explanation, he makes those. And so that doesn't make me happy.
And to address the court's concerns of what's been raised, I think the only issue out there, I have the 2 search warrants. The state asked for the AT&T timing advance records in our search warrants. The state wanted that information from Mr. Kohberger. We did not receive it. I did not receive those records from AT&T. I do not have them. Thank you, Your Honor.
He said, Mr. Ray, I don't want to, he wasn't there when we first started, and so I'm not mad. But then he went on to make the statement, but those kinds of accusations, unfounded, that would cause somebody to be disbarred. And he said it right before Ashley Jennings got up to make her statement. And of course, what did she say? The state did not receive those records. The state wanted those records. I did not receive those records from AT&T. We all know you didn't receive the records from AT&T, Ashley Jennings, because like you said, they didn't even produce the records until 2023 from the AT&T Global Legal Demand Center. But the state has been playing a game the entire time in this case. And that game has been, well, we don't know because the FBI had done whatever they did and we don't know what they did. So they've been kind of pushing things off on we don't know, the FBI did it this whole time. Judge Hippler is now becoming aware of the fact that the state is shielding the FBI and everything that they did. So things are getting interesting now because Hippler did not rule in favor of the state and say, motion in limine granted. You're not allowed to ask the FBI agent about advanced timing records. Instead, he ruled that, yeah, you can voir dire him on the stand about those records. And Ann Taylor said, I'm good with that, Judge. So it was a win for the defense, not the prosecution. And it's probably going to go a long way in destroying the state's case. So you got to pay close attention to these things, but not just in the hearing that you're watching. You got to remember everything that's happened up to that point to really grasp the entirety of the situation. It was a win. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. Till next time, Pavarotti is out.
shot, only one of me, to shield you all from the enemy. You're a superhero. You're a superhero.